And welcome back to Parallel Barking.
Woof, 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 woof.
Bark, bark.
We've got a real dog of a discussion
Of
today.
a discussion for you today.
So tell us about it, Ariana.
All right, so we have come across a couple cases.
She means she has come across.
A couple cases, actually. The first one that I ran across was one of a Chelsea Becker, who is a woman who spent 16 months in jail after she was charged with murder for having a stillbirth. And this is in a specific county in California, Kings
I
County.
remember why she was charged with the stillbirth, because she was, they claimed that she was having a drug problem, and that may or may not have been connected with the birth of the stillbirth of the child.
The events that preceded the charge were that she went to the Adventist hospital.
Yeah, she went to the hospital, and the hospital was part of the thing here. So there's all kinds of people who made this charge possible. But anyway, yeah, she was charged for stillbirth. What was the other one?
The other one is actually a case that happened earlier in 2017. It all started back in 2017.
Same county, right? In California.
The same county with a woman named Adora Perez, with an almost exact but very similar case. She also had a stillbirth and was also tested and found to have methamphetamine in her system.
Oh, well, we don't know what was in the other lady's blood, but in this case it was meth.
No, it was meth in Chelsea.
Both cases?
Yes, both
Okay.
cases.
Right.
So the same hospital calls the authorities, which in this case is the police, and
then the prosecutor chooses to charge her with the murder of a fetus.
Yes, and
there's only one problem in California, right?
Well,
the problem in California is that the statute doesn't seem to include prosecutions for in circumstances like this, highly questionable circumstances like this, for the death of a fetus. And yet they were charged under a statute, right, which the courts continue to say do not apply to these circumstances. Whatever the legislature may or may not think about these circumstances now, they have not in their wisdom chosen to criminalize the events leading up to the stillbirth of these children.
Yeah, what I think what the county prosecutor, the Kings County prosecutor, Keith Fegundes,
it doesn't matter what his name is. They're fungible administrative apparatus.
Oh, but he was the same one who did it twice.
Well, that's nice.
So, and the only one who has done it in the past 3 decades.
So the man is on a mission.
It seems
either
like
a personal mission, a political mission, a moral mission. We don't know what the mission is. He may not know what the mission is, although he is getting great coverage for this and notice among people who may share his own moral, strategic, or other views. And so he's, this is easier than TikTok, I suppose, in terms of getting noticed. The problem here for the good prosecutor, and it's actually not his problem, it's our problem, is that he's doing what in other circumstances have been lauded when the result has been a quote unquote social good. And that is, he's playing fast and loose with the text of a statute that was created by the legislature with the intention to solve a particular problem.
Mhm.
Now he's taking the text of that statute and suggesting that he can manage, I'm not going to say twist, he can manage the text of that statute to also cover the circumstances that we find ourselves with these two women in stillbirths, right? In a number of circumstances, we have hailed the heroic vanguard forces of prosecutors for doing this when it appeared to the people who are doing the hailing that this is a wonderful thing. In this case, for many people, this is an abysmal thing. You're basically every woman who gives who has a stillbirth or whose pregnancy ends without the birth of a live and healthy baby now may be subject to some kind of charge, at least in Kings County, California, because of the way they're interpreting the statute. The courts, at least in Kings County, have refused to go along for the moment, but because you're dealing with poor women and women who are distressed, I mean, in their circumstances, they can to some extent be bullied. And that was the case of Adora, I believe, of
and that's why she spent the better of 4 years, in jail.
Right.
Because she did not have access or the money to pay for counsel.
Right. Now understand that there is a law in California, and it's a good law, at least in my opinion.
Are you talking about Section 187?
Yeah, the law was written in 1970. And if I remember correctly, the law was written because there was a horrible result. A man, and it's usually a man in the cases, and certainly in 1970, a man beat I forget his partner. I don't know if they were.
It was a woman. She was pregnant, a pregnant woman.
Yeah, but I don't know if they were married or not. It doesn't really matter. His partner, she was pregnant. He beat her to death. And it was discovered, to everyone's horror, that while they can charge him for the death of the woman, they couldn't charge him for the death of the unborn child. And I forget what the circumstances were, who might or might not have been viable at the time. And that resulted in a furor and the passage. And if I remember correctly, it was a bill introduced by a conservative Republican to criminalize the death of an unborn child in this circumstance. It was sort of controversial at the time, but because the circumstances in which this arose were so heinous, people just, I mean, no one really wanted to fight this very hard.
Right. I mean, the legislation was intended for only prosecuting third parties for the willful assault on pregnant.
Right, and it was very clear that it was not meant to prosecute women in the context of stillbirths. All kinds of other things may be going on. There may be recourse to all kinds of other state interventions, but not this portion of the criminal law. And yet, this is the ultimate problem, and it's a general problem of American law in specifically, but law everywhere. And here's the basic problem. What is law? No one's going to like this, and you're not going to like this either. What is law?
Wait. Okay. Yes, you all right, go on this tangent, but then I want to talk about another part of this law.
Right. It's not a tangent, though. It's at the heart of what this prosecutor at Kings County is doing. And it's unresolved in this country, as in many countries. So the question is, what is law? And there's two fundamentally different approaches, and they can be incompatible or compatible. One approach is that the law is the wish of the legislature, right, which is then memorialized in words. And what the law is the intention of the legislature, the memory of which is written down in words, but the words aren't critically important. It was what the intention was. And so prosecutors, courts, and everyone else in the general public needs to worry about and adhere to the wishes of the legislators, because they're the ones who hold political sovereign authority, rather than adhering mindlessly to the text. That's one way of looking at what law is. The other way of looking at what law is that law isn't someone's wish. When law is reduced to text, to writing, then the law is the text, and we should not give a rat's tail about what anyone's intention was, because one, we can't figure out what the unified intention of several hundred people were, and two, it doesn't really matter because half the time when the law is old enough, they're all dead anyway, right? And so for them, the law is the text, not the
But the text can be interpreted differently by everybody.
Exactly. And that's the point. If in fact you buy the notion that law is the text detached either from history or intention, then the text will mean whatever it is that those with the power to apply it say it is at the time they apply it. And that view, which is a view which is valid in this country, that was the view that was taken, even though this guy probably has no idea, the prosecutor has no idea about anything I've just said, but he's embedded with this sensibility without being able to articulate it. That was a view that motivated this person beyond his own whatever personal demons he may have.
Well, and I totally understand that, but he also completely ignores.
Of course he can, but that's my point.
The idea or the words in the legislation that says, you know, the penal code states murder is the unlawful killing of a human being or a fetus with malice aforethought, but it doesn't apply to, quote, acts consented to by the mother of the fetus.
Okay. Now the question is, how will he take those words and interpret them? You and I would reasonably interpret them in one way. Right. And I think you and I would be in agreement that this is not a statute that I'd apply to these circumstances. And we'd apply something because we want to help these women. And we would feel horrible about the child or the fetus, depending, I don't know how viable the fetus was at the time of the stillbirth. I think in one case, it was an 8-month pregnancy, and I don't know about the other case. Right. But you feel horrible, certainly for the fetus at that late stage, and certainly for the mother. But you know, whatever it is you're going to do, whatever power you're going to apply, the state is going to apply, it can't apply this thing. And then we would say, if the state feels really strongly about this, then it is no skin off the nose of the legislature to get themselves all together and to write a statute, a criminal statute that says, but we don't have one, right? And so that would be our reasonable interpretation. Is it possible, and here's the question, is it possible? The question is, in good faith. Let me repeat that, in good faith, to then look at the text, divorced from the original intention, divorced from anything else other than the plain meaning of the text, and to, again, in good faith, find a basis in those words to prosecute these women, given the stillbirth of their children, of the fetus, right? The children, all of these are horribly politically potent terms. And so I don't mean anything by using all of these terms, which is why I'm using a bunch of them, because I'm not implying anything other than to describe the condition of the woman and her fetus. Is there a good faith way of doing it? And I'm racking my brains to figure out what a good faith way of dealing with this would be. One could, for example, perhaps in a stillbirth context, seek to prosecute the pusher who sold the meth to these women.
But see, I don't even believe that, because
I agree. I'm at the end of my rope here. I'm thinking, what could I possibly?
I know. This is all ridiculous, though, because theories about meth causing stillbirths are not. Nope. It's not proven. I mean, even
Well, definitely,
physicians,
generally, and number two, the prosecution would have had to prove specifically in this case that there is a causal connection between her ingestion and a specific set of ingestions and the result, which is the stillbirth of the child. And it's not clear that any of that. I think one of them was a plea bargain, so we never really got to trial. They bullied her into that.
yes, that was
I
the
forget,
first
and I
one,
forget the other one.
Perez.
Right, but it is important. The cases are critically important for a number of reasons. One, it's very clear that an ambitious prosecutor with a sort of esoteric sense of his authority to interpret acts could effectively terrorize women,
Especially,
who don't give birth to healthy live children.
yeah, especially in
And-
conjunction with institutions who are supporting that sort of mindset, like this
and no,
hospital.
exactly. That's number one. And number two, and for me, and that's horrible, and that's short term. For me, though, the more horrible thing, though, is if you sit back and think, if this prosecutor can assert this sort of interpretive power here, imagine what sort of serendipity he can bring to the interpretation of that vast remaining array of statutory law or even common law in California. There is effectively no way to cabin, to curtail, to manage his exercise or her, right, or their exercise of discretion against abuse. And that is something that should give us pause. This has been a running theme in this country for the last 40 years. And that is prosecutorial abuse of discretion at every phase of the prosecutor's function. And to my mind, it's not very clear yet that the Supreme Court and other courts have become much more interested in managing or curtailing abuse of administrative discretion in administrative agencies, but no one has touched prosecutors yet.
Why not? Why do you think that is?
I wish I knew. In part, I think because here's the question: do you want to, whatever rule you set up, you're always going to run the risk that you're going to over or undershoot. So the harder you make it for prosecutors, the more likely it is that people who ought to be put away will go free. The easier you make it for prosecutors, the more likely it is that the innocent are going to be swept up, or people who have no business being swept up in these exercises of prosecutorial discretion will be swept up in these exercises of the decision to prosecute. Right. So which one do you want? And that's generally the way it's framed. Is there a better way? There probably is. Has anyone spent more than 2 minutes thinking about it? Beats me, but not to the point where people who manage to influence public opinion have found it in their best interest to deal with the issue. But I feel for these women, but I also feel for the rest of us. When you've got a bunch of prosecutors, and again, this is not to disparage the great majority of prosecutors who are desperately trying to do their job under very difficult circumstances, in the context of which mistakes will be made because they're human. But then you've got the spectacular cases. And for this person, I mean, they managed to become famous, if only for 15 minutes. And to some extent, who knows where that will lead them personally.
They are on a mission. I mean, if you had a chance to read more about Fegundes, the prosecutor, he definitely dismissed the medical association's arguments about methamphetamine and how it was almost impossible for it to be used as a reason for explaining the stillbirths. He dismissed those arguments as a, quote, political position. And then he said he couldn't cite any research to support his own claims that the prosecution had the right to approach had the right approach to addiction. But when he asked why he was the only DA in the state prosecuting women for stillbirths, he said, others are fearful of the liberal media machine, the attorney general, and the governor of our legislature.
Oh, okay. So a non-response, but a political one. And that makes you think that for him, the exercise of discretion was grounded in ideology and politics.
Absolutely.
Rather than in what you would think a prosecutor would be focused on, which is the good faith application of the law and his duty of fidelity to the constitutional order, not the constitutional order he wants, but the constitutional order that exists with respect to which he has stewardship of. When he takes his prosecutor hat off, he can go and become a firebrand for any version of America he thinks is the best one, and God bless him. That's his role as a citizen, but it's certainly not his role as a prosecutor. And that's all I got to say on this puppy.
Well, he also added that in the future, he could refile cases against both Becker and Perez.
No, and he could.
But he plans not immediately to do so, but it really depends on how they proceed in their lives. So.
Oh, so the state will be constantly watching them.
Yeah, that really is like, oh, okay, so you're going to be monitoring their progress. Great.
But in a sense, that's what makes this really interesting. The chilling effect of this, at least in that county, is going to be tremendous. If I was a poor woman in this county, I would take note of this and of him. On the other hand, what it may mean is that I'm now energized enough to try to get rid of him as the county prosecutor, assuming I could.
Yeah.
Or, I mean, at this point, one wonders, there are things that you can do, I suppose. You can complain to the Bar Association. You can complain to disciplinary panels. You can continue to, just as he's monitoring these women, there's no reason that you cannot begin to hyper monitor him and begin to develop data. Who's he prosecuting? Who's he's not prosecuting? What does the data suggest in terms of prosecutions, in terms of convictions, in terms of hours that his office spends per case, in terms of how he's assigning cases to his subordinates? I mean, what's good for the goose is good for the gander. And the problem for this prosecutor, assuming that non-governmental agencies are willing to do it, is to really shift a very, very data generative gaze on the prosecutor. That becomes difficult if you're looking at all prosecutors in this country, but he's kind of exposed himself, invited this kind of thing, and it might very well be healthy for this person to get a sense of what it is like to have one's professional, I don't care about his personal life, one's professional life and one's professional actions gathered together in data and to be micro-analyzed in accordance with all kinds of analytics, and expose him in ways that he has to some extent and perhaps less fairly exposed these two women.
That's a great idea for my next analytics project. Thank you.
There you go. There you go. And I think we have done this one in. Hopefully the prosecutor and the county judiciary, as well as the county bar, will help this person. It's a male, right? Will help this gentleman to progress in his understanding and sensitivity to the law and his duty. If not, perhaps the electors will do this for him. And if not, perhaps the folks within the NGO community or our press and social media organs, well, who knows? But that's the nature of the Republic. And I look forward to our next podcast. We'll flow.
Yeah. I think some education might need to happen, like you said, some monitoring, just some resurfacing of
Not
data.
this is intense, comprehensive monitoring.
Exactly.
Intense.
Just to
Of the public record.
of the
because
public record, just to, show in a really organized, concise manner what is going on.
Rigorous and dispassionate.
Uh-huh.
And can then allow him to put a mirror up so that he can see himself in all of his glory.
I think that's perfect.
And he may like what he sees, but other people may not.
May not.
All right, until next time, woof woof.
Bark, bark. Thank you, everyone. We'll talk again.
Bye.